Hello, aspirants. Welcome back to Believers IAS Academy presents the Prelims Simplified High Yielding Topics discussion from the Polity section. And today we will be discussing the fundamental rights, not the fundamental rights, the DPSP, the Directive Principles of State Policy for the today's lecture. And we have the 10 must know questions. So, first, we will just take a quick glance of all these 10 questions, and I want you to make sure that you just try and think of an answer and also probably see if you can recall. First question: why are the directive principles often described as the conscience of the Constitution? Second, what are the key features of directive principles and how do they compare with the instrument of instructions under the Government of India Act 1935? Third question: what are the overarching goals do the directive principles seek to achieve in Indian governance? See, try and understand the question. The questions are very philosophical in nature, seems very generic, seems very basic. And this is a very simple chapter, a very small chapter, but also this is a very important chapter because the number of questions are more. And also those questions which UPSC has asked every year is either confusing or tricky. Okay, why? Because the subject matter of this chapter is kind of philosophical in nature, which you have to pay some advanced attention to understand the chapter. Moving on to the next question: how has the Constitution classified directive principles? Briefly explain the categories. Fifth one: which directive principles were added through constitutional amendments and why were they introduced? Who proposed the idea of separating rights into justiciable and non-justiciable categories, and why are DPSPs non-justiciable? What are the main criticisms of DPSPs? How has the judiciary interpreted conflicts between fundamental rights and directive principles over time? In what ways do directive principles differ from fundamental rights? Last question: why are directive principles considered essential for realizing the vision of a welfare state in India? Right, so now let's further proceed with respect to the explanations, starting with the first question: why are DPSPs often described as conscience of the Constitution? So you have to understand that these DPSPs are called the conscience because they mostly talk about the moral obligations of a state, right? Moral obligation of the state and moral vision of the Constitution, which it has put on the state to make sure that the ideals of social justice, economic democracy, and welfare is attained. Because earlier we had discussed fundamental rights as the part 3 of the Indian Constitution, which talks about fundamental rights. And this fundamental right talks about the basic right of the citizen of any country for that matter, or let's say the Indian citizen for that matter. However, this fundamental right mostly talks about the political right of an individual, and also it talks about how the individual right is being safeguarded by the state action. Mostly it is against the state actions, right? So on the other hand, this DPSPs guide state towards creating conditions where liberty is meaningful for all, especially the disadvantaged, in all the fronts, not just politically but also socially and even economically as well. Okay, so this is where the DPSP stands out, and they reflect the belief that political democracy must be complemented by social and economic democracy, and in this sense, they act as constant reminder to governments for their ethical obligations. So, hence, we can say that DPSPs are often described as the conscience of the Constitution. So, now do let me know in the comment section as to who exactly said this particular statement that DPSPs are or acts as the conscience of the Constitution. Second question: what are the key features of DPSPs and how do they compare with the instrument of instructions of the Government of India in 1935? What are the key features of directive principle state policies? Four most important. First is they are non-justiciable, unlike the fundamental rights which are justiciable in nature, right? Next is they are fundamental in the governance of any country, which means state must apply them in policy making. Means they should, or DPSPs act like the guiding light behind any policy that has to be made in a given state, and it aims to establish a welfare state, not a police state but a welfare state, and broad and flexible enough policy elevation, so evolution. So they've made a DPSPs very broad and flexible, because we're talking about DPSPs on three different fronts: the social front, the Gandhian front. I mean to say the social philosophy, the Gandhian philosophy. I mean the DPSPs which are based on three important pillars: social, your socialistic principles, the Gandhian principles, and the liberal intellectual principles, right? So they are very broad, which means they accommodate the features of all the three important principles: the socialistic principles, the Gandhian principles, and the liberal intellectual principles, to make sure that the policies in the country, they evolve over a period of time, right? Making sure it is accommodative. And in comparison with the instrument of instructions with respect to 1935 Act, it talks about the guidelines for governors, but they lacked democratic legitimacy, right? In fact, see, basically, 1935 Act, Government of India Act 1935, which had the instrument of instructions, were mostly those instructions which were given to the governors, the then governors, generals, the officers, and all of those things. Likewise, the comparison which we'll have to draw from the instrument of instructions to the DPSPs, we can say that DPSPs contrarily doesn't give directions to the bureaucrats or the executive, but they are constitutionally mandated and reflect the will of the people through the Constituent Assembly, making them more authoritative and aspirational. Right? So I hope you understood the difference. So it does not give the directions to, let's say, the bureaucrats, but they give directions to the policymakers, to the governance, as in how the governance should be functioned, right, and how a state should function. It should march towards becoming a welfare state, right? So those are the kind of lines which we have to think. Next question: what overarching goals do DPSP seek to achieve in Indian governance? DPSPs aim to transform India into a welfare state by ensuring, most important thing is, one is social justice, right, reducing inequalities, economic welfare, political empowerment, and also human dignity. So political empowerment, we can talk about the participation of women, children, right? All these, even for that matter, LGBTQ, how they've been made inclusive in our societies, right? Participation of all of them. So basically, DPSP aims to transform the entire country into a welfare state by making sure that everybody is included in the process or in this march of development or growth. So philosophically, they represent the commitment to move from mere legal equality to substantive equality. Next question: how is the Constitution classified DPSPs? Briefly explain the categories. So we have already discussed there are three major principles: socialistic principles, Gandhian principles, and liberal intellectual principles. Very important to know all those important articles within each of these principles. Like, for example, if it is about UCC, Uniform Civil Code, so you have to know it is part of liberal intellectual principles. And let's say development of cottage industries, you should know it as part of Gandhian principles, right? So I'm just giving you an example. So some of the important articles with the article number is also very important. Please make sure you make a list of all those articles which fall under each of these individual principles categories, right? Next is, which directive principles were added through constitutional amendments and why were they introduced? So we have the equal justice and free legal aid, which is part of your Article 39, which was added by the 42nd Constitutional Amendment Act. We have protection of environment and wildlife, which is Article 48 of the Indian Constitution, and also was added by 42nd Constitutional Amendment Act. Then we have participation of workers in management. This is Article 43A, and also was added in 42nd Constitutional Amendment Act. And then we have promotion of cooperative societies. Once again, this is Article 43B, what was added through the 97th Constitutional Amendment Act. So these are all some of the important additions. So these additions reflect the evolving governance priorities, because way back in one of the questions we discussed that DPSPs are made accommodative. They are made to be flexible so that they can evolve over a period of time. So this is one of the biggest example. These four important additions that DPSPs has seen over a period of time proves how it is evolving in terms of giving prominence to the governance. Also, making sure it is adding elements to protect the environment, sustainability, access to justice, and even to improve the participatory democracy as well, participatory development as well, right? So moving on to the next question: who proposed the idea of separating rights into justiciable and non-justiciable categories, and why are directive principles non-justiciable? So basically, it was told by Sir, or suggested by Sir B.N. Rao, who was a legal advisor, and it was influenced. In fact, it is influenced by Irish Constitution. Basically, the entire concept of TPSP. So where did we influence, or like where did we borrow this from? We borrowed this from the Irish Constitution. And however, the idea of separating the justiciable to the non-justiciable categories, right, was given by Sir B.N. Rao, which is also given in Lakshmikant, also very important, and supported by constitutional thinkers, Dr. B.R. Ambedkar, who was also the chairman of the drafting committee. And they are non-justiciable because of three major important reasons. One is the implementation, which required a huge amount of resources and policy choices. And also, courts cannot compel economic policy, right? So you cannot just say that divide the wealth generated by a particular individual amongst all the people just because you want economic, let's say, equality, right? So, in fact, it was very difficult or let's say, very difficult to be implemented for a country like India with so much of diversity, and also we did not have the right resources, right? And the flexibility is needed for democratic decision making. So, flexibility was also required in terms of making these kind of decisions, which were also very important. So hence this was made non-justiciable in nature. So this the philosophy is that social transformation must be pursued politically, not mere judicially. Means it has to be done through legislation. People should accept, right? The representatives who are representing the people, they should accept it. The law should be legislated, not just because the judiciary wants it, through certain verdicts, right? I hope you got the point. Next is, what are the main criticisms of DPSPs? Well, there are a few. The first one is they are non-justiciable, making them appear symbolic. Next, some provisions are vague. Implementation depends on political will. See, these are all some of the important things which are not that really important for the prelims examination, but it is good to know. Potential conflict with fundamental rights. This we have seen time and again, and there is a separate section in the Lakshmikant book where you will have to talk, or let's say you will have to definitely study about this, the conflict with fundamental rights, as to what is superior. Is it the fundamental rights or is it the DPSP? We have three different cases. We have Champakam Dwayarajan case 1950, and then we have Golaknath case 1967. Then comes the Keshwananda Bharati case, and after that, the 42nd Constitutional Amendment Act 1976, something happened, and then the famous Minerva Mill case 1980, right? So, this entire chain of evolution is also very important. You have to know. How has the judiciary interpreted conflicts between fundamental rights and DPSPs over time? Judiciary, right? Judicial interpretation. Initially, they said fundamental rights were given primacy. Later, courts emphasized harmony between them. Basic structure doctrine recognized that both are essential to the constitution. So, this was the the chain of evolution that I was talking about. So, in the Champakam, simply we'll just discuss Champakam Dwayarajan case. What was told? Fundamental rights were made supreme over the DPSP. Means if there is a conflict between DPSP and fundamental right will be supreme. Means fundamental right becomes supreme, right? And also it said that DPSPs act as subordinates. They act as subordinate to fundamental rights, right? And also, here we have to keep in mind that it also said that fundamental rights can be amended to give, or let's say to enact any particular DPSP. And later in the Golaknath case, the famous Golaknath case, it said, the verdict came out that fundamental rights cannot be amended to implement DPSPs. And likewise, following that, the Parliament enacted two important Constitutional Amendment Acts, 24th and 25th. 24th Constitutional Amendment Act clearly stated that Parliament can now amend any fundamental right to, let's say, implement a DPSP. And then the Constitutional Amendment Act 25 added another article, Article 31B, if I'm not wrong, Article 31B or 31C, yeah. it added Article 31C, which gave two important provisions. One, it said no law, right? Article 31C, the first provision, it said no law which is trying to implement Article 39BC of the Directive Principles of State Policies shall be called void, right? Shall be called void, stating that it is abrogating fundamental rights, especially Article 14 and Article 19, right? So there was another provision also under the Article 31C. It said that any law that tries to implement this by amending the fundamental right to give effect to Article 39B and C cannot be judicially reviewed. Cannot be judicially reviewed. So then comes your Keshwananda Bharati case 1973, where the Supreme Court said that the first provision is constitutional. However, the second provision is not constitutional. It is null and void because judicial review is the basic structure of the Indian Constitution. So you understand the story. It is the fight of supremacy between judiciary and the legislature, right? And following this 1976 42nd Constitutional Amendment Act. So that was done, and in this particular Constitutional Amendment Act, what was pretty much narrowed in the clause 1 of 39C was now widened. Means only those socialistic principles under Article 39BC, which if they wanted to implement, they could have amended a fundamental right, now was made more wider. Means earlier, which was only specific to 39B and C, now was given for the entire DPSP. So now under 42nd Constitutional Amendment Act 1976, the Parliament said that any DPSPs can be added, or let's say in order to implement any DPSP, fundamental rights can be amended, right? So once again, fundamental rights, the priority was given less. The DPSP's priority, the superiority for DPSP went up. Then again came the Minerva Mills case 1980. So here finally came to an understanding that it is neither the fundamental rights nor the DPSPs which is superior. Both are like the two wheels of a cart. Both are like the bedrock of the Indian Constitution. Both are very important for the harmonious function of the state. So hence, both are important. So doesn't mean that fundamental rights cannot be amended. Doesn't mean that the DPSPs cannot be amended. It means right now, what are the present stance is the fundamental rights can be amended to implement any DPSP, provided that the basic structure which is given by the 1973 Keshwananda Bharati case, the basic structure doctrine, is not destroyed. Okay, so this is the present stance. So it's a beautiful evolution of how the fight between the judiciary and the legislature happened. So it's very good to know, and pretty much like a mains concept as well. Okay, next question. In what ways do DPSPs differ from fundamental rights? We have the key differences. One is with respect to the enforceability. Fundamental rights are enforceable, DPSPs are not. In terms of nature, fundamental rights protect individuals. DPSPs, they guide the state. In terms of the objective, fundamental rights ensure political democracy. DPSPs aim socio-economic democracy. So this is very important. Questions can be made in these points here. In terms of the legal status, violation of fundamental rights can be challenged, but DPSPs cannot. Scope, the fundamental rights are specific, DPSPs are broad policy. These fundamental rights, they talk about the specific right, specific problem, specific violations. But DPSPs, they are pretty much talking about, or let's say, has very broad policy rules. Next, in terms of the orientation, fundamental rights are negative obligations and DPSPs are positive. What does that mean? Fundamental rights are negative obligations means it puts restrictions on the state. That state should not do this, right? This, if you do, the consequences are this. It's a negative obligations. Rather, DPSPs are positive. Means now it is telling the state in a positive way, you have to do this. State must work for the welfare of its people, especially for the downtrodden, especially for the poor, especially for the children, right? In fact, you have one beautiful Article 45, the right to elementary education. Right, the right to elementary education is the responsibility of the state to make sure the child or the children below the age of 14 must be given the basic education, and that later was taken and made a fundamental right, Article 21A. Correct? So DPSPs are like positive in nature. They have a positive tone, like what the state should do. And on the other hand, the fundamental rights have a negative voice where it says what state should not do. Right? So that is about the difference between fundamental rights and DPSPs, and together they create a balanced constitutional framework. Balanced constitutional framework created by both of them, and they both fundamental rights and DPSP, they act as the philosophical part of the constitution as well. So this is also very important. Next one, why are directive principles considered essential for realizing the vision of a welfare state in India? The answer is they provide the blueprint for inclusive development by arguing the state to address poverty, inequality, education, health, and social security. They ensure that governance is not limited to maintaining order but actively promotes human well being. Philosophically, they represent the Constitution's commitment to transforming society, moving from colonial deprivation to democratic empowerment, and ensuring that freedom has a real substance in people's lives. So this is all beautifully given in Lakshmikant. Very much sufficient, if you just understood all these 10 questions. Anyway, that's all for this particular video. Signing off, this is Madan Gopal. Have a beautiful day.